Hey, welcome back, guys. Advocates for Justice Paralegal School. We are different and we prove it. Welcome back tonight. Tonight, we're going to talk about, I'm going to introduce the upgrades we've done to our credit card defense lawsuit package. As soon as we get everything lined out here. Hope you guys had a good weekend. Also want to tell you guys about our new eliminating property tax lawsuit package. We got a brand new offer that we posted on Sam's Cart. And we've added a few extra things to the eliminating property tax lawsuit package also to beef it up. We're beefing up stuff up in here. So let's just get started. So this package has the credit card defense lawsuit package has become extremely popular. So I'm adding a little something to it to make it pop just a little bit more, because that's what we do around here. So I like to make sure that you guys know how much I enjoy teaching folks all over the place, punch people up in the face. People are the attorneys, punch the attorneys up in the face. So our private Facebook page helps us be able to do this. And the real-time feedback we get from the members in the group allow me to make changes, adjustments, add stuff to take care of the corruption and fraud that they're doing to us. So the group has really helped out, and now we're benefiting from it. So the first new bomb I'm adding to the credit card defense lawsuit package is my new jurisdictional challenge with an affidavit. I'm sure you guys have heard me talk about that document. And the great thing about that document is what we use to stop the state court process. So if you're in a credit card lawsuit situation where they dragged your butt in court already, this package is going to have what you need. Now, it already had what you needed, but we really didn't have tools to actually stop the process in state court and jam it down their throat. And that's what this jurisdictional challenge with an affidavit does, if you use it properly. Now, you can go to my website and check out the jurisdictional challenge with an affidavit playlist or the jurisdiction playlist, and you can find it. In the instructional video playlist, we have all the instructional videos that you need for the packages. So if you're new to this, you can go there and get the information that you need. Now, all of those 148 videos that I have on the website are the videos that pretty much go over stuff that I have in lawsuit packages, okay? The videos are designed for the people who are doing this on their own, so they can go and get done what they need to do and have access to the strategies and goals that we use. Now, if you don't have time to do this yourself, then sure, we got the packages and stuff ready to go for you. All you got to do is just head over to my website at winningcourtnow.com and pick up what you need. There you go. That's my email address. Oh, that's my teacher. We're going to send you everywhere else except for where you need to be. Oh, that's okay. Anyway, winincourtnow.com is the address to my website. So we'll just make a banner right now. winincourtnow.com. There you go. There's the right thing. We'll get it going here. So let's see if we have anybody watching yet. So let's just move forward, because that's what we do around here. We keep moving forward. So this document package is jamming up the attorney's program all across the United States of America. I'm talking about the jurisdictional challenge with an affidavit. We've added that to the credit card defense lawsuit package. And we want to make sure that if you are already dragged in court, you don't have to start from the beginning of the process. I want to make sure you have something to stick up in the attorney's face and mess up their case in state court. And that's what the jurisdictional challenge with an affidavit is for. And I've added it to this package so that when people use it, they can get control of the case in court while they're figuring out where they need to get their paperwork filed to file their own lawsuit against the attorneys acting as third-party debt collector, trying to collect on the debt on behalf of somebody else. The whole thing that they're doing is fraud. So we're going to help you guys address that. So the attorneys have not been able to respond by counter affidavit because they're lying. So when you use my jurisdictional challenge with an affidavit, you should be ready. You should already have your notice of default ready, because the judge will have to help them kick your ass. And the second bomb that we've added to this package is the magistrate judge reconsideration package. Now, I put a magistrate judge on there. It doesn't matter what judge it is. I just put a magistrate judge because usually the magistrate judge is the one that's throwing your shit out. So don't get hung up on the words, okay? Because it don't matter what judge it is. And this document is badass, and we'll get to that here in a minute. So if the judge helps the attorney by dismissing your pleadings, you have the second new bomb in the lawsuit package to handle that issue. Now I'm adding the reconsideration package to this credit card defense lawsuit package. So you'll have what you need to object, to file your notice of recusal of the judge, and to file your notice of claim against the judge for helping the attorneys violate you. So the real-time feedback I received from our 585 private Facebook group members helped me set up the strategies and the documents that we're using to stop their fraud. If it wasn't for their fraud and corruption, my documents would stop everything right at the gate. There wouldn't even be a hearing. But there is the fraud, and that's what we need to learn how to navigate. And we need to do that in a non-conventional manner, and not do it in their conventional program where the argument starts and then the judge gets to help them. We all know how that goes. So if you've been dragged into court already, the jurisdictional challenge with an affidavit will destroy their state case right up in their face. And I'm adding that. I'm pretty much going to add that to all of my packages, because I want you to be able to stop the process so you can get yourself out on the 50-yard line, so you can throw some passes down the field in the end zone. That's how we do it. So you will force the judge to allow the attorneys to violate the law and the court rules, and they will all violate your rights trying to get you under control. And that's pretty much what my documents are about. We attack them. I understand the loopholes and their procedures and policies, and I put them together to help you guys in the documents to help you guys get them under control. So once a judge violates your rights, you will need to use the other package, the magistrate judge reconsideration package with the civil claim against a state court judge in federal court. Or you could file your lawsuit in their case. If you're struggling and don't have the money, the $400 to spend in state court, then you could file this lawsuit in their case as a counterclaim, and then you just add the attorneys to your lawsuit to their lawsuit against you, just like you would if it was the other way around. Yep, no, they don't do that, but you can, because we do it all the time. and they get a little pissed off about it too. But hey, we don't have to walk down the path that they laid out for us, because we already know they're going to take shots at us the whole time we're doing that. So we ain't doing that. We're going to walk down a different path when we can take shots at their asses. So that's what we're going to do. So what I did here, what we want you guys to do was file the civil claim in state court to get it on the record. Now, you can do that. Now, the ideal situation would be to drag their butts into the higher court, but that's in a perfect world. Sometime if you don't have the $400 to spend in federal court, then you can do it this way. The goal is to stay in court and cost them money while you build your record, challenging the jurisdiction. So when the judge helps them, you'll have everything on the record you need to jump on the judge's face. Now, I have done this. I actually have filed a civil claim in state court to get it on the record. And then when they finally found another judge, because that's going to be the problem. Once you jam the judge up with your reconsideration package and file your claim and recuse the judge is going to have a problem. And the other judges, when they get in the way, they're going to be worried about what you're doing, because you're not going down the same path that they're used to. So it's going to be like a hot potato. Your case is going to be like a hot potato. Now, I did this, and since I actually filed my claim against a traffic court judge, and once I got the claim filed on the record, I actually filed to move my case over to federal court. And I removed the case and moved it to federal court because the judges in state court had a conflict. And since the case was already on the record, the federal court was forced to allow me to proceed without paying fees. Now, I wouldn't advise this for everybody, but if you're in a situation where you got time and you're not worried about them kicking you off the edge of the cliff or throwing you out or getting a judgment against you, then you can do this too if you want to. Okay, the dispute that I dragged in the federal court was over two $10 seatbelt tickets. I actually mentioned this in a story on one of my videos, and I did that just because I like to screw with them. So, yeah. Now, I'm not trying to go before the judge because done that already. So my goal is not to go before the judge. It's to make them not want to have you in court. Now, when the judge helps the other attorneys, you can sue the judge for violating your rights. And they're not used to folks doing that. Okay? They're used to folks filing an appeal and wasting your time and the rest of your money asking their friends to help you. Now, we've been learning how to cut to the chase and jump on the judge's ass as soon as you need to. As soon as they violate your rights, you need to jump on the judge's ass, get up in their face, because if you don't, they're going to continue to do that the whole time. And pretty much, you know how that's going to roll. They'll be kicking your stuff out and finding a judgment for them fools. And the next thing you know, they'll be attacking your bank account or trying to garnish your wages. When you challenge jurisdiction, you cannot continue to file documents in your case, or you're passing up your challenge and allowing the process to continue. So if you're already in court and you use a jurisdictional challenge with an affidavit, that can be your answer to them, or your response. Excuse me, we never answer, we respond. You can always respond challenging a jurisdiction before you have to file an answer. Okay. So that'll be your response to a jurisdictional challenge with an affidavit. And when you file that, you're not going to file all of the rest of the stuff in your packet. You're going to wait till they respond. And if they don't respond in a timely manner, and I had a lady look at research, and she said her rule said 50 days. Oh, hell no. I would give them whatever amount of days you wanted to give them. to further your situation that you're trying to get under control. Like, for instance, if you're looking at a sale in 2 weeks, then you're not going to give them 2 weeks. You're going to give them like 2 freaking days. That's what I would do. Because at the end of the day, it don't matter how much time you give them, or if they want to complain about the fact you didn't give them the amount of days they had or whatever, they can complain about that and do what they want. But you need to do what you need to do to protect your to protect your property. So you give them the amount of time that you think you need to give them to give you a chance to get in court and be fair, because the process ain't fair for you. And you need to remember, the judge cannot respond to your jurisdictional challenge with an affidavit or just a jurisdictional challenge. The judge cannot respond to that. Okay? The attorneys that filed the case, whoever the party that filed the case, is the one that must respond. And the attorneys must hire attorneys after you added them to your claim, because they're not allowed to represent themselves in court, and they can't litigate a case they're a party to. And most attorneys are not going to want to help them when they find out that you know the gig and that they're illegally collecting and acting as a third-party debt collector. Now, the filing party must prove jurisdiction on the record in court. If the judge interferes by dismissing your challenge, you must file your claim against the judge ASAP. You must review the federal rules of civil procedure to figure out how long the attorneys have to respond, and then you get to reply to their response before the judge can get involved. Now, like I just said, depending on your situation, you may not want to give them the whole amount of time that the federal rules of civil procedure say they get. And if they want to complain about that, then the judge can give them more time or whatever after you jam them up. But then you'll be the one in charge. You'll be the one in control and running the show. And that's the plan. Now, I would not follow their rules. I would force the attorneys to respond in a time frame that helps further your situation, just like I said. Now, you can challenge jurisdiction at any time up to 15 years. So you can slap this in their face at any time along the process. And when they try to tell you the case is closed, you tell them bullshit. The case is never closed until you sit down and give up. And then you can point out in the document. In the document, I have it outlined, and the case law right there that shows that you can challenge jurisdiction up to 15 years. And I would let them know it ain't been 15 years. So they need to fire your shit and get out of your face, or they're going to be in trouble, because they will be violating 18 U.S.C. 1602, obstruction of correspondence, which carries, I think, a 1-year jail term and a $5,000 fine or something like that. So you're going to sue the judge for helping the attorneys, and you will be driver of the bus. Now, the other document that that's already in the packages are listed below. And I'm going to do a screen share in a little while and show you the documents that you get. This motion to dismiss the credit card lawsuit will be the first document that you file in a court case if you don't have a jurisdictional challenge with an affidavit. Now, I've added the jurisdictional challenge with an affidavit, so you should have it. You should use that document to control the whole case. And if they try to screw you over, then you're going to file your lawsuit for the judge violating your rights by taking jurisdiction without legal authority. And I have a new package on my website that specifically addresses the judge illegally dismissing your case without jurisdiction. It specifically addresses that. So I have a link here I'm going to post for the credit card lawsuit package, so that you guys can, if there's anybody that's interested in that, you can get that and get going with that before they drag you into court. It's a lot easier to control things before you get into court than it is to control them after they're already beating you up. So, but we can do it either way. So I think I would save the motion. Now, in this package, there's a sanction motion for $5.5 million, or you can put whatever amount on it you want. And that sanction motion addresses the fact that these attorneys are supposed to do a reasonable pre-file investigation before they file this stuff in court, and they never do. If they did, they wouldn't file it because they would know that there's no injured party. And so we don't even want to get into all of that. But that's what they're supposed to do. I would probably save the sanction motion and use it if they come up with an attorney to help them. If they find an attorney that's not affiliated with their law firm, then I would use the sanction motion and stick in that attorney's face and make them go sit the hell down. Now, the lawsuit for the Fair Debt Collection Act practice violation is structured to be filed in federal court, but you can file it in state court if you want to. I have a case law that supports the fact that you can file federal case law in state court. There's no difference than filing Supreme Court case law in state or federal court, because federal court is a higher court, and you can file case law from federal court in state court. They don't like it one bit because it forces them to follow the precedents, and they don't like it. They complain about it and all that shit, but they can't do a damn thing about it. You leave it in there and don't allow them to let you turn it and change it. Now, the Fair Debt Collection Act practice lawsuit is structured to be filed in federal court. However, I just said you can file it in state court using it as a counterclaim if you need to. And that's if you don't have the money to file it in federal court, then you can do that and still take control of the situation. And make sure to add the attorneys to your counterclaim as the number one defendant. And you just change it. You change the format on the front, and you add the attorneys in the plaintiff's area. Yep, you just add them right underneath the plaintiffs. Matter of fact, I would remove the lender and just put the attorneys on there, because the lender, there's no lender. They done a charge off already and sold the debt to these people that are coming after you without standing. So there's no lender. So I would just add the attorneys on there and hold that sucker responsible. So remaining documents are structured to harass attorneys, and when I show them to you, you'll see what I mean. And you can file them anytime if you want to. I would wait till they respond, and if they don't respond, go ahead and default them. If they try and respond, then you can sit them with the rest of your stuff and beat them down, just like they've been trying to do you. This package contains everything you need to take control and sue the attorneys and the judge for violating your rights. When you add the third-party debt collecting attorney to his claim or to your claim in federal court, they're screwed. And I guarantee you'll have some fun with this. Now I'm going to open up the share window and share a couple of documents so you guys can see what they look like. Okay. So the share window is open, and this is the jurisdictional challenge with an affidavit package. And as you see here, you have 6 documents. This first one is the jurisdictional challenge. Oh, it opened in the wrong. We'll just move it down here. Open in the wrong one. This is jurisdictional challenge with an affidavit. Now, a lot of people get tripped up on this because of the Texas Attorney General's office. Now, you're going to change this to put your state, okay? And then obviously you're going to put your name in place of John Allen Doe, and the attorney's name goes down here, okay? And the Texas, whoever your state is, Attorney General's office, that's whose name goes here. And you want to, and I would I would serve this on the Attorney General, or at least mail it to them where they have to sign for it. And this is a little bit different concept of what people are used to. So I have people that they get caught up on this, and I just tell them, look, don't worry about whose name is here. Replace the red font with the information that you need to personalize the document and file it. And the reason that we have this set up like this is because, well, for a couple of reasons. If you sue the judge, you're going to have to serve the Attorney General's office. If you sue a state officer, you're going to serve the Attorney General's office. So you might as well go ahead and get the Attorney General's office included in this before any decisions are made. And who knows, maybe that will prompt someone getting on the phone, making a phone call to see what the hell is going on. Maybe that'll change. I don't know. But that's what we're doing, and it's working out pretty well. Now, the other thing that people get hung up on is the case number and the file number. Now, you don't know the file number, so I would leave the file number all zeros. But I would leave this file number here, and then put your case number here. The file number is the administrative file number of your case. They don't know that you know there's an administrative file number. But when you have this file number written here, you're letting them know that you think there is a file number, and letting them know that you are not the average person that they're getting to stomp in the face. Oh, and see, here it is. Furthermore, the Supreme Court of the United States has ruled that jurisdiction can be challenged at any time, even as much as 15 years after the judgment has been entered. So when they tell you guys the case is closed, you need to let them know, no, it's not closed. We're going to open it up again. And if they refuse to file your documents, you need to let them know that they're actually obstructing the administration of justice, and they're in violation of 18 U.S.C. 1602, obstruction of correspondence. And it carries a jail term. Okay, so this document here is the demand for default. Now, these attorneys cannot respond to a jurisdictional challenge with an affidavit. One, because they're lying and they can't sign the affidavit. So if they can't respond by counter affidavit, then it's a non-response. And if they haven't responded in the number of days that you provided for them to respond, then I would file my demand for default and move forward, because we don't want to sit around and wait. And as you can see, all you got to do is change the red font with your information and stick it in their face. I tried to make this as easy as possible. I mean, there are still a lot of people that tell me I need to change this and change that and change this and change that. But a lot of times people don't understand that these documents are designed to be filed in federal court. And that means that people can use them in any state. And that's the way we set it up. Now, there is some homework that you have to do in some of the documents, because you have to change the codes. But if you got to change the codes, if you're looking for the foreclosure code for your state, then you would just, or foreclosure statute for your state, then you would just look up foreclosure statute for Illinois and Google that. And it'll pull up and most of the time it'll pull up within 2 or 3 entries from the top of the page, or maybe at the top of the page. So a lot of people struggle with that, but it's pretty simple. Okay. Now, we're still on the jurisdictional challenge here with an affidavit. I think it has 6 documents in it. This is the motion for a summary judgment. And if you see up here, I put in care of. That means that this is not where you live. This is just where you receive your mail. Because if you are a state citizen of the Republic state you were born in, then this is how you would write your shit on there, so that they can know that you don't live in Washington, D.C. and you're not a U.S. citizen. Now, the motion for summary judgment is pretty straightforward, and it's pretty short. Now, this is how you are going to write your address. Rule route delivery, put your address here, and then leave all zeros, okay? That means you don't live in their whatever the hell they call it, where they can control you and say you're one of their a federal government employee or a federal government citizen. Pretty simple. Now, after you file your motion for summary judgment, oh, here's one we need to talk about too. I like this one. They had a hard time responding to this one. This is a motion to move all of their pleadings filed by the attorneys until the attorneys prove subject matter jurisdiction on the court record. Now, this one you want to file the same time you file your jurisdictional challenge with an affidavit. And this backs them into a huge corner. Matter of fact, the first time we used this for a family member, they weren't able to respond to the jurisdictional challenge with an affidavit by counter affidavit. They responded with some stupid shit. And they never did respond to this. They asked for a continuance to respond to this, and they never did respond to it. And so we jammed them up about it. And eventually the judge tried to ignore everything. And we slapped the judge with the new document package that we put together to sue the judge for taking jurisdiction without legal authority. And we also filed a restraining order against the attorneys to block them from continuing filing shit in the case until, So now we check the docket sheet, and they have a new attorney. So that'll be the seventh attorney now that they just signed up. And I'm waiting for him to send something or do something so that we can file the motion to demand to strike the attorney's notice of appearance, because the attorney is a foreign agent, and that's why they have to file the notice of appearance in court, because they're a foreign agent. But the problem is they're not properly registered with the Foreign Agent Registration Act, and they haven't filled out the paperwork with the National Attorney General's office. And if they're not registered, the Foreign Agent Registration Act was enacted into federal law in 1938. And if they have not followed that, then they have no standing to be in court up in your face. And I'm working on a document for that right now. Next week, I should have that finished next week. So you can see this is the fire. The goal is not to go before the judge so the judge can rule on your stuff. Okay, the goal is to stay in the ring and keep your shit in their face that you need to sue them with. And next we're going to, motion for a hearing. This one we put together to demand a hearing. As soon as I can find it and get it down here. And so this is just a motion for a hearing on a jurisdiction challenge with an affidavit. So after you get after you get all your stuff filed and they haven't responded, and or you can file this anytime, but I would wait till last and file it to jam them up and push things along. And now the move. Notice of default. We had to add this in here so you'll be ready, because I already know they're not going to be able to answer. So you probably should have your notice of default already ready, because I'm telling you right now, they're not going to be able to answer. And then I put together, just for the fun of it, I put together this reply to the attorney's response to a jurisdictional challenge and affidavit. and motion to dismiss for lack of subject matter jurisdiction. So in case they do respond with some cheap blah, 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 then you have some badass blah, 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 blah you can stick in their face. So that's what this one is about. Now, remember, when you're using this jurisdictional challenge with affidavit, you're not going to file a bunch of extra stuff or allow them to move forward or do anything. You're going to jam them up. And as soon as the judge helps them, you're going to jam the judge up with the package we're going to talk about next. So your goal is to get off of that credit card crap, because you never want to go into court talking about the lies that they want to talk about. Because if you do, you're doomed. So that's it on that one. And now we're going to look at the one that, oh, I love this package. This one, you're going to have some fun with this. Now, the first one here is, oh, yeah. I get excited when it's time to kick the judge's ass. Yeah. So this is the notice of claim against the judge for violating the Administrative Procedures Act of 1946, obstruction of the administration of justice, and violation of the Constitution, constitutional rights under the color of law by making a determination without jurisdiction. And now, the Administrative Procedures Act of 1946 is badass. It's serious. They do not want to mess with that. Now, it's an administrative issue, so you can't get money for that. And that's why we added these other things. And, I'm looking at this thinking I forgot to put the $5.5 million on here, but I'm sure you won't forget to do that before you file it in court, right? So the Administrative Procedures Act of 1946 was actually enacted into law, in federal law, and the goal of that law was to force these corporations to make sure that their policies and procedures were in line with the Constitution, and they're not. So if you sue them for this, you can't get money for this part of it, but you can for this part of it. But you can certainly, if you win, you can certainly make them change their policies and procedures to be in line with the Constitution. And they ain't trying to do that, because the minute they do that, they stop making money. And the the obstruction of the administration of justice, that's how you make your claim. Most people think it's, they're violating due process. That's for criminal court. In civil court, you want to say they're obstructing the administration of justice. And when you come that way, they know that you got a legal team that's getting your back. Okay, because not many people know that. And this is really important. These words mean all the difference. A lot of people don't realize that when you're talking to these attorneys, or you're talking to the bar members in court, or you're talking to the clerk, they're picking your brain to figure out if you know what the hell you're talking about. So if you allow them in court to get you off track and talk about the payments or any of that crap, then you're going to be struggling, because they're going to know that you don't really believe what you're doing. You should only be talking about what's in the freaking documents here. That's all you should be talking about with these fools. You want to make them think you believe this stuff, even if you have no idea what the hell it is. You can read the words and you can recite the words to them and tell them, all you got to do is just get close. But you got to do it with some passion, like you mean it. How's that? Okay, you got it? And you can see this is serious. We've added all of the stuff here that we need to add on here. The only thing we didn't add is the RICO on here. But we don't need the RICO because the Administrative Procedures Act is pretty badass. And I haven't seen anybody, I have used that to control people, to control corporations for a while. And they do not like it. Okay, let's move on to the next one. So, This one is the inventory notice of recusal. So most people don't realize that it's pretty easy to recuse a judge, especially when they are screwing up. Okay, because in order to recuse a judge, you don't have to prove that they violated your rights. All you have to do is show the appearance of impartiality, and then you can ask the judge to step the hell down. And when you file this and you file your notice of claim, the notice of claim is actually the claim. It just says notice. To make it a claim, just take notice off and you put your money on there, your money amount, your $5.5 million, and turn that into the claim. And so you can see this, you just have to change the red font. Now, there might be a couple of places where I missed something. If it don't make sense and it's missing a word, just add the word. Don't take nothing out or change nothing huge. But every once in a while, there's a typo because I suck at typing. So you might find a typo or you might find a grammar error. Just change it and go and move forward. Because at the end of the day, it's not going to be about none of this. At the end of the day, it's going to be about you going down to the judge for helping the attorneys get a free pass. Now, we've also added an appeal or a notice of appeal template. Now, I don't have any faith in any processes that involve attorneys or bar members. So I don't really suggest filing a notice of appeal unless you need time. If you need to stop things and you need time, well, actually, the jurisdictional challenge was an affidavit. The jurisdictional affidavit should do all of that. But this is here just in case you're there. You need to file this to give yourself time to get your shit together. Okay, that's why I put it in here. I don't really use this because I think it's a waste of your freaking time. Why should you do appeal when they violate you? Just sue their ass and be done with that shit. That's what we're learning how to do. Cut to the chase. We learn how to cut to the chase. Hey, James Galley. And the magistrate judge consent form. I put that in here so people could check it out. The magistrate judge does not have jurisdiction to be involved in your case without consent from all parties. And I was having this conversation with my wife, and she was disagreeing with me. And then I Googled magistrate judge consent form in Texas and pulled it up. And I gave it to her, and she looked at it, and she said, "Oh my God, you're right." And of course, I started laughing. I said, "Could you say that a few more times? A couple of more times? That I'm right?" Okay, let me stay focused. So you can see here, this is a pretty serious thing. Now, a lot of times they'll send you a document asking if you want to consent to the magistrate judge to be involved in your case. And most people just throw it in the trash. I would take a black marker and write, "Hell no, I don't want the magistrate judge involved in my case." And I would sign and date it. And I would send them a copy of it and keep a copy for yourself and ask them to file it in your case. Because no one wants to have a lesser judge to make ruling in your case. And let me tell you how this goes while we're talking about this magistrate judge crap. Most people don't realize that the magistrate judge is the one that dismisses your case. Right. No, I know. It came from the district judge's office, desk, or whatever. But if you look at it close, you'll see that the district judge sent your case, especially if you're using my stuff, they sent your case to the magistrate judge so the magistrate judge could dispose of it. And what the magistrate judge does is the magistrate judge will review it and figure out some kind of way to dismiss it for failure to state a claim under Rule 12B. And I actually have a video on how to state a claim properly and rewrite your lawsuit it's on my YouTube channel. You can go check it out if you want to do that. But the magistrate judge will write a report to dismiss your case. And the magistrate judge will send that report up to the district judge. And then the district judge will dismiss your case based off the magistrate judge's report, not based off of the finding of facts and conclusions of law, which is what they're supposed to do. But most people don't catch that. And if you don't catch that, what just happened to you was they dragged your ass in an administrative process, and they use an administrative process to dismiss your shit. That's what they do. Check. You think I'm off base, you go check your records. The magistrate judge dismiss your case, you go check. I'll bet you that on that district judge's report, they said the case was dismissed based off a report from the magistrate judge, not off of a decision based off of conclusions of facts and findings of law. So that's the problem. And once the magistrate judge does that, I would file my claim against the magistrate judge. Don't wait. What you need to do is you need to figure out a way to sue them for screwing you over. Okay? Don't wait and then wait for the judge to make a ruling on all those lies that they said. As soon as they screw you over, it's time to sue them. Seems to me, I mean, I'm from the hood. That's how you do it. And that works a whole lot better because now you're not having to go and pack your stuff. Or in this case, you're not having to worry about them garnishing your wages and stealing your paycheck or getting in your bank account. I've had people come to me and they actually got in their bank account. And here's the other thing. On a debt collection, when they get the judgment and win, okay, that doesn't give them the right to get in your bank account. They have to go to administrative court and go through another process and hearing and give you a chance to defend before they start taking your money. But they don't do that because people don't know. And they use the original judgment to make you think that that gives them the right to take your money. And how they trick your employer is they use an administrative packet that's a wage garnishment package, a packet with all of the documents in it, the forms that they fill out. These forms have specific wording that's kind of stern and scares your employer, and they send this stuff over to them, and it's not signed by a judge anywhere. They do this shit all day to people. It's not signed by a judge anywhere. So they start garnishing your wages based off this packet that they downloaded off the internet. Now, how do I know this? Because I helped a lot of people. And when I help people, I take a look at the document. I look at the whole document. If there's little tiny numbers underneath the number, I got the magnifying glass and I'm looking at that shit trying to see what it is. And one day I saw the numbers and I copy and pasted them and I pasted them into Google and I hit the button and it pulls up the packet that they were using. It's a packet of documents that they use so they can get around dragging your ass back into the administrative court because they don't have time for that. They just need to take your money and move on to the next. Yep, that's what they do. So now that you know that, if they're stealing your money from on a wage garnishment, shoot, I'd be going in the office and asking to talk to whoever's in charge of the risk department, RISK, the risk department, or the legal department, or whoever it is that you're going to be adding to your lawsuit and suing them for stealing your money when the judge ain't signed shit. So that's how that goes. So I think that's everything in that document package. Now, this is the credit card lawsuit package, and I don't have the actual updates in this one, but the one that's on the computer has the updates in it. So when you purchase it, it'll show the updates. Now, this here is your lawsuit for the Fair Debt Collection Act practice violation. Let me move down here so you guys can see it. And as you can see, now this 1.5 million, you can change whatever you want to put on it. I like to use 5.5 million, but I went down on this one because we filed it in state court the last time we used it. And you can see here that you're going after the attorneys for violating the Foreign Agent Registration Act of 1938. And we talked about that earlier in the video. That is a federal law enacted into law in 1938. And these attorneys are supposed to register with the National Attorney General's Office and the Department of Justice. And They're supposed to provide a lot of information about who they work for, how much they charge, all this stuff, but they never do. And if they don't have that information available for you to look at and review, then they're not legally doing what they're supposed to be doing, to have standing to be up in your face. And that's huge. Now, I have people telling me all the time, well, I brought that up and they didn't do nothing about it. Well, the judge ain't gonna, they're buddies. They play golf. The judge ain't gonna, you're gonna have to sue them and do something about it yourself. That's how you do that. And that's what we do with this. And you can look up for the Foreign Agent Registration Act of 1938, and you can take a look at it, and you can see that it's pretty powerful. I wonder why nobody uses it. Well, we finna start using it now. Yeah. Now, this is, I have some really cool stuff. This is your demand to strike the attorney's notice of appearance from the court record, because the corporation cannot represent itself in court. Now, you can add to this that you're demanding to strike the notice of appearance because the attorney is not registered, doesn't have the foreign agent registration documentation presentable. They have not registered with the National Attorney General's office, so they're in violation of federal law. It's plain and simple. They're in violation of the federal law. This is what I like to do. I like to find their loopholes and help you stick them right back up in their face. So you can see, all you got to do is change the red font. It's not that much red font, and most of these to be changed. Now we got the affidavit template. We won't open that up because that's, well, maybe we will. We'll just show it to you. This is the affidavit, and you just change the red font with your information, write your facts down here about, what's going on. Pretty straightforward. And we have a notice of removal in case you need to remove the state court's crap over to federal court. So if the judge tries to ignore your challenge of jurisdiction, well, we already have a plan for that. This stuff we put together before we had the jurisdictional challenge with an affidavit bomb to stick in their face. But you can see how it rolls, and it's pretty short and plain. So, and then we have this motion here. We try to make sure that you have everything that you need. Now, this package is on sale for $200, and I'm going to leave it there for a while. The motion to dismiss with prejudice for lack of subject matter jurisdiction. This is what you can use to dismiss their whole case with. But I would jam them up with the jurisdictional challenge with an affidavit first, because that's more badass. And that stops everything at the gate. But you got this too. Like I said, we put the bombs in here. You guys just need to learn it so you can stick it in their face when you talk to them. And this is the motion that I used to use before I got really educated about all the stuff that I'm doing now. Put this motion together, and we jam the attorneys up with the sanction motion. But yeah, 1.5 million in sanctions for pursuant to Rule 11. And you can see here, you just got to put the attorney's name on there and change the red font. So this package with the two new packages we add to this credit card defense lawsuit package, you'll be able to control the whole program. And I think that's pretty much it. And I put a link to the credit card lawsuit package. I'm going to post a link on there again for people to see. And that's all I got for the screens. Oh, I want to share one more thing with you guys. One second. Now, this is my new offer that I put together for the Eliminate Property Tax Lawsuit package. And we've added the same documents that we just added to the other package to it. So if someone is facing a tax lien foreclosure, or they're coming after your property tax, HOA, any of that stuff, this package would be perfect for you. And I'm going to put the link in the group so people will be able to use it if they need it. We've updated it, and it took me a lot of work putting this website together, but it came out really cool, I think. So if you have rental properties that you need to protect, this would be perfect. If you have rental property that you're going to be jammed up on with property tax and stuff, you can use this to take care of that situation. And the Constitution and property taxes, you can see there that taxing private property is illegal in the Constitution. And the Supreme Court ruling ruled that municipalities cannot exert any acts of ownership and control over property that is not owned by them. That's pretty plain and simple. The Supreme Court right here. Yeah, and I love this picture of the attorney getting handcuffed. So I might be dreaming a little bit there, but you know what? You got to dream big, and then you got to make it happen. Just talks about the civil liability. And then we're right here. Invest in this package so that you can force the attorney to follow the real estate deed transfer laws and deliver the deed to you, so that you can force the city to follow the Constitution and eliminate the property taxes. You need to invest in this package so you can stop the property tax lien foreclosure process, block the eviction process, block the tax lien sale. You can do all of that with this. And you know what? If you're in foreclosure and you want to do something different, this property tax attack would be perfect, because when they've illegally registered your deed in the county recorder's office, that allowed the lender to file the fake mortgage lien against your property. Remember, your property was paid for in full when you signed that promissory note, and they processed it through the Federal Reserve. They turned it into a check, into a security, and processed it through the Federal Reserve. Okay, so and I have attorneys argue with me all the time on this, and this is what I tell them: they're full of crap, and here's why. If you have several people that own property, and someone's going to put that, and they have to sign to agree to a lien against that property, all the people that own that property have to be there present to sign, right? Right. So the fact that the bank accepted your signature on the alleged paperwork on the lien against your property proves that you own the property free and clear, or they wouldn't have been able to accept your signature on it. Bam. Keep it simple. Keep it simple. So people need to invest in this package so that they can operate their short-term rental business, Or they can save the money for a new car. How about that? But that's going to get some attention. Or block the city from controlling how you use your property. Or you can block them from interfering with how you want to operate your Airbnb. They can't harass you anymore. So we stroll on down, and this is the picture that I use for this. Who wouldn't click on 2 bags of property tax money? That's yours. That's your money. And so this is what you get. And this is all the documents that's outlined in this package. And then we have our reviews. Now I have about 4 or 5 reviews on the property tax. I think the reason I don't have more is because these attorneys are making people, sign a non-disclosure statement when they have to come to the table and settle. And I think that's what's going on. And I think that because I've had 2 people that led me to believe that. So, and then here's all the free stuff that you're going to get. And I just made this video today talking about the free stuff. And here's your jurisdictional challenge with an affidavit that comes with 6 documents. And then you're also going to get the magistrate judge reconsideration package so you can sue them when they throw you under the bus. And then we got a video on attorney fraud. And then it's time to stop this. Yeah, I love this picture. And then my guarantee. So I have a 1-week guarantee on the online course, I have a week guarantee. On the lawsuit packages like this, you need to study or do your homework before you purchase it because there's no guarantee with this. What I guarantee you is that you'll enjoy it. You'll have fun. That's my guarantee on the lawsuit package. And the lawsuit package is $500. And I reduced it when the coronavirus started. I reduced it from $850 to $500, and that's where it's still at right now today. So that's all I got today. I will see you guys in the next video. Thanks for hanging out with me, James. I hope your situation is going pretty good. And if you have anybody messing with you for a credit card lawsuit, this is the package that you need. And it's fire.